by our Chief Technical Guru. Good morning, ladies and gentlemen, and welcome to the launch of Willing to Work, the National Inquiry into Employment Discrimination against Older People and People with a Disability. I start by acknowledging that we meet on the tribal lands of the Eora people, the Gadigal tribe, and pay my respects to their elders past and present and to other Indigenous elders who are with us today. Of course, a special welcome to our guest, the Honourable George Brandis QC. George Brandis is, of course, our Attorney General. He is the Minister for the Arts. He's been a member of the Senate representing the state of Queensland for 15 years and has previously served as Minister for the Arts and Sport in the Howard government. So Senator Brandis is very welcome for all of those reasons. I would also like to pass on the apologies of the Commission's President, Gillian Triggs. Gillian is very sorry to be missing this event, but she had an unavoidable commitment in Melbourne. However, I am very pleased to welcome my Commissioner colleagues, Commissioner Tim Wilson, Commissioner Mick Gooda, and Commissioner Tim Soutphommasane, and almost one of ours, Ros Croucher, the President of the Australian Law Reform Commission, who works with us so closely on so much of our important work. Well, thank you, Attorney, for joining us today. I do take it as a powerful sign of the importance that you and your government attach to the subject of this work that you have come here personally to the Commission to launch it. As our guests here today are aware, the Attorney has invited the Commission to conduct a national inquiry into employment discrimination against older people and people with disability. And the Commission has warmly welcomed this request. I'm honoured, Attorney, to be leading the inquiry with the full support of the Commission. Team Commission is very well represented here today. So, Attorney, I would now like to invite you to say a few words to launch our inquiry.
Thank you very much indeed, Susan. Can I also acknowledge the traditional custodians of the land on which we meet? Can I, as well as you, Susan, acknowledge the Human Rights Commissioner, Tim Wilson, the Aboriginal and Torres Strait Islander Social Justice Commissioner, Mick Gooda, the Race Discrimination Commissioner, Tim Soutphommasane, the President of the Australian Law Reform Commission, Professor Rosalind Croucher, the Secretary of the Attorney General's Department, Chris Moratis, the Secretary of the Department of Social Services, Finn Pratt, other distinguished guests, ladies and gentlemen. I want to begin with an apology this morning on behalf of my colleague, Senator Mitch Fifield, the Assistant Minister for Social Services, who, of course, has immediate portfolio responsibility for much of the areas to be covered by this inquiry. I've just got off the phone from Senator Fifield, who is, of course, a very strong supporter of this inquiry, and he asked me to convey his apologies and good wishes. I am delighted to be here this morning to launch the Australian Human Rights Commission's Willing to Work inquiry, formerly called the National Inquiry into Employment Discrimination and Discrimination against Older Australians and Australians with a Disability, to be conducted under the very able leadership of Commissioner Susan Ryan. My mind has been much concerned and occupied with the question of discrimination in workplace discrimination, particularly against older people, in recent days and months. Earlier this year, I announced the appointment to the High Court of Geoffrey Nettle, the oldest person ever to be appointed to the High Court of Australia at the age of 64. And it crossed my mind that it was a shame that somebody of his great ability would only be able to serve on the court for 5.5 years. Yesterday, I announced the appointment to the court of Michelle Gordon, one of the youngest people to have been appointed to the court, but once again, whose capacity to contribute to the court will expire when she reaches the statutory retirement age of 70 years. In both cases, those judges replaced High Court judges who, or will replace High Court judges who were at the peak of their capacity to contribute, but because of the artificial statutory ceiling of 70 years, are required to retire. I am just old enough myself to remember the 1977 referendum, when that provision was introduced into the Australian Constitution by the Fraser government. I thought it was a mistake then. I voted no. But reflecting on that referendum, and there will be some in the room who will remember it, the debate that was had in this country then would be inconceivable today. It would be inconceivable today that as a matter of public policy, a matter of relatively uncontroversial public policy at the time, a government saw fit, and the population by majority supported it, to impose a statutory ceiling upon a person's capacity to contribute to senior office. Today, we have a much more sophisticated understanding and appreciation of the capacity of older Australians, and of course Australians with a disability, to contribute fully to the workforce, just as they contribute fully to all areas of society. So although we've come a long way since the referendum, there is still a lot more to be done, particularly when it comes to employment discrimination. That is what brings us here today. It's an important issue that actually affects millions of Australians and potentially affects every Australian sooner or later. The evidence is clear and undeniable. Employment rates for older Australians and people with a disability remain at disturbingly low levels, and we know that is largely as a result of discrimination. I've heard many stories from people who are more than capable of making an extraordinary contribution to the workforce, but are prevented from doing so because of their age or because they have a disability. But this is not just about them. It's about all of us, and how, as a nation, we want to treat our fellow Australians. We know that underemployment that results from discrimination and unemployment that results from discrimination has a significant economic and social cost. As the recent intergenerational report recognises, our society needs to value the contribution of all Australians who are able to work and who want to continue to work. In addition to the benefit to individuals, harnessing the economic potential of all Australians assists to stimulate the economy and avoid over-reliance on the welfare system. We have an obligation to the next generation to ensure that we capitalise on the potential and lost opportunity of that demographic. The right to work is a core part of the enjoyment of individual rights and liberties. Where the right to work, free from discrimination, is affected, other rights become less meaningful, less able to be achieved. Employment is essential to individual economic security and to physical and mental health. The importance of gainful employment cannot be understated. It provides a sense of self-worth and of being able to make a contribution to the community. Discrimination is consistently reported as one of the most significant barriers to employment for mature age workers and persons with a disability. It's faced both during the recruitment process itself and in the workplace. In 2012, the Australian Bureau of Statistics reported that workforce participation of Australians with a disability was only 53%, and that participation rate had decreased since 2009. It's more pleasing that mature age workforce participation has increased in recent years, but there is more that can be done to increase it from its current rate of around only 13%. And of course, workplace discrimination is not just an issue for those workers and workplaces involved, but for the wider community. Many employers are already realising the benefits of employing older Australians and Australians with a disability, aided by government programs such as the National Disability Strategy and assisted by work of the Commission, such as the Power of Oldness campaign, for which Commissioner Ryan has led. I'm sure, Commissioner, you would agree with me that there remains more to be done. In fact, not only would you agree with me, but you will be leading it. We need to think about how we can change negative attitudes and stereotypes. We need to identify best practice on how to recruit and retain people, including what reasonable adjustments can be efficiently and effectively made to support mature age workers and people with a disability in the workplace. In closing, can I offer this observation? An effective human rights agenda is one that focuses on outcomes, not rhetoric. As you know, over the last couple of years, the Human Rights Commission devoted considerable resources to an inquiry that was largely a problem arising from a previous government and which had largely been solved by the current government. And the diversion of those resources to that inquiry attracted criticism from the Prime Minister and me. I'm keen to focus the Human Rights Commission's work and resources on matters that have a contemporary and practical relevance for millions of Australians. And that is one of the reasons why I asked the Commission to prioritise this inquiry, which the government will fully support, and hope the Commission, in the allocation of its priorities, will fully support as well. I'm confident in the leadership of Commissioner Ryan. I'm confident that with her enthusiasm, her skill, her experience, and her commitment, the inquiry will make a measurable difference to the lives of potentially millions of Australians, older Australians and Australians with a disability, and in doing so, permanently change the culture and the expectations of our country. Those words, I want to once again thank Commissioner Ryan for taking on this very important task and launch the inquiry. Thank you.
Well, Attorney, you have certainly got us off to a great start. I think everyone understands the importance that you and the government attach to correcting these areas of discrimination and these denials of human rights. And for us at the Commission, it is most encouraging and energising, I might say, to hear you speak so with such commitment and with such understanding of the issues that we are facing. And I can only say you've set us a very high bar. We'll do our very best to reach it. And I know my Commissioner colleagues and the staff here will assist me. I'll just say a few remarks about the the inquiry itself and how it might proceed. The terms of the inquiry you gave us, Attorney, are very good. They're very broad, they're comprehensive. They will require us to look at all of the factors that impede the successful employment of the two groups of Australians whose opportunities are at the heart of this exercise. We'll examine, amongst other things, practices, attitudes, Commonwealth laws that deny or diminish equal opportunity in employment by the two groups. And as a result of this, Attorney, we will make recommendations as to Commonwealth laws that should be made or amended, action that should be taken, and other processes that could be changed to address this terrible area of employment discrimination. And Attorney, I really have to say that your decision to bring this work to our attention is timely and it is much needed. We do know, as you have pointed out to our friends here this morning, that employment rates for both groups are far too low. And we also know they don't need to be so low, because when we look at comparable countries in the OECD, we will find that several countries are far ahead of us in this activity. In employment of people with disability, for example, we are only 21st out of 29 OECD countries. Attorney, that need not be the case. It should not be the case, and that's what we're addressing. And we know, because you've reminded us this morning of the disparity between the numbers of people in the community who have a disability and the very small number who are able to pursue active employment. Again, with the age population, where, as you say, Attorney, we're looking at everyone, because if you don't die, you get old. These are the two options, and I know which one I prefer and am pursuing. So The intergenerational report, despite a particular scientist deciding to have second thoughts about it, as we heard this morning, is a very important reminder of this fact, and this is cannot be contested by a scientist or anyone else. The demographic revolution has occurred. We are living it. We are part of it. This is not an area for contention. We are living a generation more than our immediate forebears did. This is happening all over the world, but in Australia, of course, it's happening under the very benign circumstances of our life in Australia, where we have better health than ever before, we have better education than ever before. So we should be harvesting the fruits of the demographic revolution. And this was a very important message of the intergenerational report, which I, for one, was very pleased to welcome and engage in discussion about. The area of disability discrimination in employment also is one not only that the attorney and I have seen as important, but when you first appointed me to this role as Disability Commissioner Attorney, I conducted a survey and had a very broadly representative forum of people with disability themselves, their carers and advocates, and they nominated, after social inclusion, their top priority, access to employment, as the most important thing that they saw as giving them equal opportunity as Australian citizens. We know there's a huge economic dimension to all this. In terms of the ageing population, some work I commissioned from Deloitte a couple of years ago pointed out that if we could increase the participation of Australians over 55 in the workforce by just 5%, we would get a $48 billion a year annual impact on the budget, which is why I think your colleague, Attorney, the Treasurer, is also very keen to see some progress in this work. So the economic dimensions are huge, but as you reminded me when we first discussed this work, Attorney, we're not the Productivity Commission. They can roll out all of that economic data. We are the Human Rights Commission. And as you've noted, the right to work is a fundamental human right. If people are denied that simply because of prejudice and discrimination, this is a violation of their rights. It is intolerable from a human rights perspective that people are excluded from exercising the right to work simply because of discrimination based on the number of years they've been alive or discrimination based on the fact that they have a disability. So the task of this inquiry now is to identify the barriers that have prevented all of those willing workers from being able to exercise their right to work. We will be consulting as much of Australia as we have the capacity to do. We will be having consultations in capital cities and some regional areas, and they will be notified well in advance on our website, which is just being constructed now. We will also have the opportunity for people to make submissions themselves through our website, online, and writing to us in any way they want to let us know. We want to hear from employers, large and small, public and private sectors, and I'm very pleased, Attorney, that we have senior members of the Australian Public Service here today, because as I've discussed with your Commissioner of the APS, John Lloyd, we have a very poor representation of people with disability in the Australian Public Service, something I know you will be as keen as I am to see that change. We have improvements with employment opportunity for older Australians. There's no doubt that the APS has become aware of the value of experience and is exercising the flexibility they have to do that. We are optimistic that we will see change here. Although it's a huge challenge, it's a challenge for which we can see solutions. And when we've had discussions with the employers, the employer bodies, the recruiters, the human resource specialists, and the people themselves, older people themselves through their organisations and individually, people with disability through their representative organisations individually, we believe we can make big changes. And I think it's important to note that we already have in Australia some of our major companies who have understood the value of including such people. And I'll just mention a few of them just to show that there are some positive stories. Westpac, for example, Westpac, amongst their employment base, has 12% of people with disability. And given that the rate across the population is 15%, you have to say Westpac has taken this seriously. And please note, Westpac is a very profitable organisation. So they've included people, but they have included people with disability as part of their business strategy. ANZ is implementing a whole of business strategy to ensure that all of its products and services are accessible to people with disability. That's everything that you do in banking, the ATMs, online banking, all of those things will be totally accessible. Again, they're doing this because they have a commitment to it, but also because they see the business benefit of making sure they are accessible to the whole customer base. And I can never have a discussion about admirable employers without mentioning my favourite, Bunnings. Everyone knows about Bunnings, but really I repeat it because Bunnings have made such a success of deliberately employing older people, particularly people who find it very hard otherwise to get jobs, men who have been working in building and construction or have been tradesmen all their lives, who get to a stage where their physical strength doesn't enable them to continue, but who have such a lifetime knowledge of all of the materials and processes involved in building that people like me, or perhaps I could even say the attorney, when we go to Bunnings to find out what to do about the leaky bathroom floor, we actually don't. You may know, attorney, I know you know many things, but I don't. And the fact that there are these skilled, experienced people there working in retail is marvellously helpful to customers. And of course, we know that Bunnings is an extremely successful organisation and part of the extremely successful Wesfarmers Group. We attended a function recently with Bunnings and your colleague, the Treasurer, and they had an 83-year-old employee there at the Bunnings store, and he is not the only one. And he was very happy to describe how purposeful he found his job, and plenty of customers were very pleased that he was there. And I conclude with these because what we're attempting is not impossible. Some of these corporations that I've mentioned have worked out how to do it and do it successfully. Do it as a business strategy, but at the same time ensuring that the right to work of these people is being implemented. So we're hoping for engagement from all of Australia in this because it is a national issue. I'm optimistic, but I know that we will need to get the engagement of the employers, the employer groups, the people themselves, if we are to produce for you, attorney, a report that meets the very rigorous criteria you've set out for us, a report that will make a difference. So the inquiry will be opening now, and we will continue taking submissions until the middle of next year, and we will report to you, attorney, as required by July 2016. So thank you very much, and I now invite questions about the inquiry from the media in particular. Questions from the media? Nick?
For those on the basis of disability, for example, why are they not enough, and how do you see potentially those laws being strengthened? Is it a difficult thing to police?
Well, the laws are there. The Disability Discrimination Act was enacted in 1992. The Age Discrimination Act was enacted in 2004. They are there, and they make it unlawful to deny people jobs, goods and services and so on those bases. The laws are constructed so that an individual who's experienced this kind of discrimination can bring a complaint here to the Commission, have that investigated and conciliated. Thousands of people do that every year, and about half of our complaints are successfully conciliated. The most complaints that come into Commission under all of our anti-discrimination laws are in the area of disability. The lowest level of complaints are in age discrimination. But in age discrimination, the vast majority have to do with employment matters, either getting a job, keeping a job, recruitment, and so on. Should the laws be stronger? Well, I think that we need the law as a backbone to what we're doing. But to me, the real challenge is changing attitudes, and that's in the first instance the employers, opening their minds to the benefits. And now I don't think we do that by laws that will have them scurrying around trying to see how they can evade them. I will listen to what the employers themselves say, but at this stage I would say the laws do offer an individual remedy, and those individual remedies are often successfully pursued. The cultural change that we want, the understanding of the opportunities that being more diverse employer represents, I think really is a matter for advocacy, leadership, discussion, and hard evidence.
So what are some of those perceptions, false or otherwise, about older Australians and Australians with disabilities that might be barriers to employers?
Well, in the minds of many employers in Australia, you don't want to employ someone over 50 because, and this is what they believe, they won't adapt to change, they won't learn new things, they won't get on with the dynamic younger employees, and they won't be worth any investment in training you make. They'll be sick more often, they'll have more time off for sickness and injury. Now, none of that is supported by the evidence, but it is still believed by too many employers. What we need to do is keep producing evidence, presenting it to employers, pointing out the folly of their ways. I mean, Attorney, you drew our attention to the folly we all committed back in 1977, because I think I did vote for that referendum. I mean, I was about 33 or something. I thought, oh yes, 70 is too old to be a High Court judge. I don't think that now. So I think those beliefs are very ingrained, and they're ingrained through an organisation. You find the human resource people who do the actual hiring and firing of it. They're also ingrained in the minds of recruiters. Now, you know, most companies now do their recruiting externally, so they go through recruiting businesses. Recruiting businesses make their money, develop their business by getting you placed in a position. If I'm a recruiter and I think that you're too old for an employer, I won't even put your name forward. So the structure of the recruiting businesses works against people just being examined in terms of, can you do the job? What have you done before? Are you reliable? So that has to be tackled. When it comes to people with disability, I think there is genuine lack of confidence on the part of employers as to what is entailed in hiring a person with a disability. They don't know, they think what their responsibilities are, what the reasonable adjustments will be. They're not sure how to have the discussion with an employee with a disability as to what will be needed to make that employment successful. And so they just shy away and say it's too hard. But we know it's not too hard because, as I've given you the example of Westpac, who haven't found it too hard at all. Australian Public Service, take note. So, you know, more information, more helpful information, not badgering employers, but pointing out how they can get assistance and support and what the benefits are, I think will produce what we want to produce.
Look, I'll go one more then. Do you think it's too easy for people to get away with discrimination in the recruitment process? I mean, maybe not actually marking it down as a reason for someone not getting the job, but sort of there being an unspoken agreement that someone might be too old or unsuitable for the job.
Look, it is too easy because an employer or a recruiter who might think that you're too old for a job doesn't have to tell you that. They can. A very common thing told to older experienced workers is, oh, you're overqualified. Now, I don't know what overqualified means. I mean, if you worked in a certain area but you now want to work in another area, you're probably, you know, overqualified is not a meaningful thing, but people are often told that. I'm amazed still, though, that some employers do just say, oh, we think you're too old, or you're too old for us to bother retraining. So when that's said, the conciliation investigation is, of course, much easier to produce a satisfactory result. But the attitudinal thing that people complain about a lot of just being edged out, not included, told your qualifications aren't up to date, but no offer to retrain you, I think it is too easy. What the solution to that will be, I hope, will emerge in our discussions over the next 15 months. Would anyone else like to ask a question about the inquiry? Otherwise, we might thank the attorney and move on. I think we're fine. Well, again, thank you, attorney. It is really extremely important that you've lent your presence to this launch. It will certainly help put it on the national agenda so that when I contact employers and so forth, they'll know that this is happening, and I hope they will cooperate. I share your hopes for the outcome of the inquiry, and I will do my very best to make sure those hopes are realised. So I'll ask you all to thank the Honourable George Brandis QC, who has launched our inquiry this morning.